Hello. It's quite clear that when it comes to liquidation for a succession, estate settlement, the liquidator, the executor, is the person mostly responsible for the process. Liquidators sometimes. Uh, and heirs often think that everything is owed to them, but they don't owe anything to the estate, which can bring up a situation of a so-called abusive heir, when the heir's behavior might impede or even impede the process of liquidation, or aggravate the financial situation of the estate, and therefore the heir might be seen as an abusive one, and her behavior might be seen as reprehensible, and there might be responsibility towards the estate, towards other heirs, towards some other creditors, and so forth. Let's remember that the liquidator, the executor, is not first of all responsible towards heirs. If there is a will, then the first responsibility is towards the testator, towards his or her wishes as expressed in the will. So if the heirs want something else and think that they might direct the liquidator, the executor, to act upon their wishes, it's not true. And if they try to force, and sometimes even try to go to court trying to force the liquidator to do that, this might be seen as abusive behavior. Because again, the testator is technically the one who mandated the liquidator to act, not the heirs, if there was a will. But even if there was no will, or for any other reason, if the person was installed, designated, nominated properly as the liquidator, maybe by court order, maybe in front of a notary, maybe by simple registration by election with the Revenue Quebec, still, that person's responsibility is not first of all towards heirs. This is why usually the same heirs cannot simply remove by the same vote. That person's responsibility is usually, first of all, towards the creditors, because before anything can be distributed to the heirs, or some benefits could be vested, the liquidator, the executor, should make it sure that the debts are paid, including taxes, those towards the estate. But there might be others, like outstanding some litigations, some credit cards, credit lines, some contracts to sell some property, for example, to somebody already signed but not executed yet, or some other contracts where, for example, now it's impossible to perform because it was directly connected to the personality, and therefore there might be some payback or maybe some fees and penalties for the breach of contract. Who knows what might it be? Might be some judgments against that deceased person to pay something to somebody. Or again, as I mentioned, there might be ongoing litigations where there might be some debt and so forth. So whatever the best interests and the wishes of the heirs. If the liquidator goes with that, the liquidator might be personally responsible. So there might be a situation when heirs are not happy with the actions of the liquidator. Even among the heirs, there is a sort of hierarchy. Because if there is a will, for example, where it says that, okay, this book, this motorcycle goes to my nephew, and this brick chimney goes to my niece, and left wheel of my car goes to my grandchild John, and the other one goes to my grandchild Christina, for example, something like that. Then even if the so-called universal or residual heirs, those who I mentioned, like everything else goes to, if they see that at the end they might have almost nothing if everything is paid, and they might even see it as unfair or wrong or whatever, it's it's their liquidator's responsibility to proceed in that order. Like creditors first, heirs by particular title second, and only then the residual heirs. And maybe the residual heirs would prefer some different distribution of some like particular things that are not mentioned in the will. Jewelry is the most usual example. Again, normally, if they cannot get to any kind of agreement, the liquidator's job would be to sell everything and to distribute the money in proportion according to the will, which might get enraged everyone, particularly because if one of the heirs actually being really interested in those particular items would act as a buyer, giving like a fair market price for all those jewelry pieces, therefore like having bought them from the estate and then compensated of sorts, having his or her proportionate share in the monetary value of that, that might again enrage everybody else. And again, that the liquidator must act according to the will and according to the rules and regulations first, and only then the wishes of the heirs. So in such a situation, or sometimes when the heir already sees that the will is not going or the distribution does not go the way he or she wants, or because one of the heirs is also a debtor towards the estate. For example, there was a contract or some sort of an agreement, or money was borrowed from, let's say, somebody's father or mother. Now, he or she died, and then the estate wishes to collect that debt from one of the children, and that child thinks that it's unfair, and that child is not cooperating, and so forth and so forth. So that there might be a situation. And as the code brings up clearly what are the obligations of the liquidator, but not so clearly, as it seems, what are the duties, obligations of the heirs. Heirs might think that they can sabotage impede the liquidation process in any way they want, and it will be not their problem after all. So they could simply just sit there and do nothing and do not allow, for example, to sell some piece of land or a building or the investments or whatever, so that everybody else is also blocked because of this particular person's resistance, because this particular person, for example, does not deliver some piece of paper which he or she got from the house of the deceased person when they just did some cleaning up, and now refuses to deliver. For example, that happens. There are even worse situations when somebody finds a later will which excludes that person and destroys that will or hides that will. And of course, there is always an issue of evidence. If it can be proven, then there is a sanction as disinheriting that person, like declaring that person unworthy to inherit, but that's another story. So, what can be seen as abusive behavior on the part of the heirs? Usually it's about not providing something, because actively doing something, it's usually the liquidator's job. But not providing information, for example, somebody knows that somewhere in Switzerland, Australia, or Argentina, there is some bank account belonging to the deceased, but that information is withheld, or at least that person says, okay, go to Argentina on your own and find that out. I'm not giving it to you. That behavior, it's not simply like unpleasant, nasty, stupid, whatever. It causes damage, monetary damage to the estate, because in the absence of that information, the liquidator is obliged to undertake certain steps which are costly to retrieve that information. Same about documents. Uh, and therefore they might be claiming personal responsibility against those heirs for this abusive kind of behavior. Because again, that information, those documents, property, it all belongs to the estate. And many heirs wrongly think that the estate belongs to them, but no, the estate does not belong to heirs. Uh, the property, what's left of it, starts to belong to heirs only from the moment when it's distributed to them, not before. And there is no guarantee, because of all those debts and obligations of the estate, that they will receive the property they are expecting, actually. Not to mention that the will might be not to their satisfaction, but that's another story. If heirs think that, okay, well, this came to my hands, I will never let it back. I want this painting, I want this book, I want this heirloom, I want this piece of jewelry. This money was moved to my account before my father's or my mother's or grandmother's death, and now it's with me and nothing like that. Then again, the estate might have a claim for the property against that person, for the unlawful detention, possession of that property. And if the judge sees that the behavior of the heir was intentional, illicit, there might be sanctions, not to mention the order to deliver the property. Sometimes, if there is no will, or if the will does not provide for full administration of the property, as the powers of the liquidators, the heir's consent, all the heir's consent is needed to sell some piece of property. And let's say one of the heirs doesn't want to sell, that heir wants to have that piece of property at a lower price than the market one, or like even for free sometimes, for him or herself. Therefore, that person, for example, that person is living in that property. That person is doing whatever he or she can do to block the sale, for example, withholding his or her consent. By that, again, potentially causing monetary damage to the estate, and again, exposing him or herself for some sort of liability because of that. So when the heirs like clearly obstruct the liquidation process, thus causing damage to the estate, to other heirs, just behaving abusively, they might be sued and they might receive a judgment against them, causing them to pay sometimes significantly more than they thought would be the cost of their actions or inactions. It's true that the estate will pay for all those legal steps. Therefore, they will all pay, including those heirs who do not act abusively. But again, those losses, to a certain point, under certain conditions, of course, consult your own lawyer, but they can be claimed from that abusive heir. And sometimes that abusive heir might face a situation when he or she not only has to perform or provide, but also to pay on top of that. Sometimes, like all of his or her share in the estate being disinherited, sometimes like hundreds of $1,000s just to compensate for the damage. It might be a big deal, actually. So, if you're an heir and you are not satisfied with the way as it is going on, and you think that it's unfair and it should have been done in a different way, and because of that you act out of spite, remember that it might cost you. Thank you and have a nice day.